Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McInnes Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. On Friday, June 21, the Supreme Court of Canada delivered its decision in an interesting privacy case called York Regional District School Board versus the Elementary Teachers Federation of Ontario. The decision considers how the Charter applies, and specifically Section 8, related to search and seizure, to public school boards, particularly with respect to dealings and discipline of employees. In this case, two teachers employed at Mount Joy Public School, York Region, faced issues shortly after the 2014-2015 school year. They believed that another teacher was ineffective and unfairly favored by the school principal. Concerned about their performance reviews, one of the teachers sought union advice and was told to document her concerns. So that teacher began a private log on her Google account, personal Google account, shared with another teacher, accessible only to them via their internet browser. They accessed the log via their work laptops. Although its existence was known within the school, its content remained private. Several staff members reported a toxic environment and suspected that teachers were keeping a log. The principal, after consulting with the board superintendent and human resources, initiated a search, presumably of their systems, but found nothing in the board's files. On December 16th, the principal accessed the teacher's laptop and discovered the log, taking photos with his phone of about 100 entries. He reported this to the superintendent, confiscated the laptops, and shared the log with the board. Despite searches, no log files were found on the laptops. In January 2015, the board disciplined the teachers for improper conduct, citing the use of board technology to maintain the log during work hours. They received written reprimands, valid for 3 years. The union grieves this discipline, seeking to rescind the reprimand and claiming $15,000 in damages for each teacher for privacy breaches. By the end of the arbitration hearing, over 3 years later, the reprimands were already removed from the teachers' files. The parties focused on the privacy rights breach claim at the arbitration. The arbitrator's decision centered on whether the teachers had a reasonable expectation of privacy regarding the log they kept, and if that expectation of privacy was breached by the actions of the school principal and the board. The findings of the arbitrator were, with respect to the expectation of privacy, concluded the teachers had a diminished expectation of privacy concerning the information accessible on the board's laptops because they were not for their exclusive use, were unsecured, and the log was not stored on the laptops but on the teacher's private Google account. With respect to the reasonable cause for the search, the arbitrator found that the principal had a duty under the Education Act to ensure a safe school environment, which justified a reasonable search without prior judicial authorization. Given the toxic work environment, there was ample cause, the arbitrator concluded, for the board to search its IT platforms for any shared files. Now, the principal touched the mouse pad and turned on the laptop, and apparently he had the authority to ensure that the laptops were turned off. By touching the mouse pad and seeing the document log on Google Docs, he found that log by happenstance. And since they concluded it was left in plain view, the teacher should have expected it could be seen by anybody who touched the laptop. Now, with respect to looking at the log itself, since the log was left visible, the teacher had a diminished expectation of privacy, and the principal's initial viewing of the log did not breach this expectation. Now, when it came to scrolling through the log and taking screenshots, the arbitrator concluded that the log did not contain intimate personal information, but rather notes on workplace happenings and observations about colleagues, which were already known. Thus, scrolling through the log and taking screenshots did not breach the teacher's privacy. With respect to then the subsequent forensic search of the computers, the arbitrator concluded it was reasonable for the board to search the laptops to see if the log was stored on them. This search was conducted reasonably and did not breach the teacher's expectation of privacy. So in summary, the arbitrator concluded that while the teachers had a subjective expectation of privacy in their log, this expectation was diminished due to its visibility on the workplace laptop. The actions thus taken by the principal and the board were deemed reasonable and justified, considering the circumstances and the need to maintain a safe and orderly school environment. Thus, the arbitrator held that the teacher's privacy rights were not breached by the principal or by the board. The case then went to the Divisional Court of Ontario, only on the question of the expectation of privacy in the work laptop. Now, that court upheld the arbitrator's decision, and this is really where the charter comes center stage. The majority of the 3 judges concluded that the charter did not apply here, but a dissenting judge leaned pretty heavily on the charter, writing, "In this case, the arbitrator was required to balance the griever's rights under Section 8 of the charter against the statutory objectives that the principal was seeking to enforce under Section 265 of the Education Act, maintaining proper order and discipline in the school and developing cooperation and coordination of effort among the members of the staff of the school. A reasonable decision is one where the charter right at issue is impaired no more than is necessary given the statutory objectives." At paragraph 112, the judge wrote, "Employees should be disciplined for what they do, not for what they think and what they say in a private communication. The arbitrator's decision allowed a school board to access what are essentially the private thoughts and communications of 2 of the teachers. To permit this in the name of maintaining order and discipline or developing coordination and cooperation among staff members is to unjustifiably impair the charter rights of teachers and potentially other people in the workplace far more than is necessary." So the majority of that court says no charter in play, and the dissenting judge says heck yeah. So off to the Ontario Court of Appeal. The Court of Appeal had a very different take. They concluded that the charter did apply and that looking at the log was akin to looking at one's diary. From paragraph 56 of the Court of Appeal's decision, quote, "The griever's log was in essence their diary. They were entitled to record their private thoughts, including complaints about coworkers and supervisors, for their own purposes, and to expect that those thoughts would remain private." And then at paragraph 67, the court writes, "Once the principal realized he was looking at the griever's log, it was as though he had found their diary. He had no legitimate purpose in reading it, let alone taking screenshots of it and submitting it to the board. The principal failed to respect the griever's reasonable expectation of privacy." The Court of Appeal also concluded that the teachers did make efforts to secure the log and that it became available to the principal due to inadvertence. Whether a search is reasonable needs to be looked at within the full context. Principals may have an increased duty when it comes to the safety of students, but they're agents of the employer when dealing with the workplace. So even if it's been characterized as toxic, the Court of Appeal found a charter violation and then quashed the arbitrator's decision. So it's then appealed to the Supreme Court of Canada. A lot of the discussion in the Supreme Court of Canada's decision revolves around whether the charter applies to a school board, whether it applies in the employment context, and whether it's up to an arbitrator dealing with a grievance under a collective agreement to address and then apply the charter. The Supreme Court agreed with the Court of Appeal that the charter does apply to school boards in all that they do, including managing their workplaces. At least in Ontario, the court said, quote, "Public education is inherently a governmental function. Ontario public school boards are manifestations of the government, and thus they are subject to the charter under Eldridge's first branch." The court then goes on and says, quote, "All actions carried on by Ontario public school boards are subject to charter scrutiny, including the principal's actions in this case, as he acted in his official capacity as an agent of the board, a statutory delegate, and not in his personal capacity." And they also made it clear that arbitrators have an ability and, in fact, the obligation to determine charter issues that are linked to matters that are properly before them, and that they must act consistently with the charter and its values. The court also notes in paragraph 90 that it's an access to justice issue, and I agree with that. Our courts are already overburdened. Imagine the result if the court had said, yeah, the charter applies to everything the school board does, but you'd have to begin an arbitration to determine the issues about the collective agreement while also going to the Superior Court to have the charter question considered. That would be duplicative. So in the circumstances of this case, how does the Section 8 right to be free from unreasonable search and seizure play out? Well, principals can't go out and get search warrants. Some criminal law cases have arisen in the educational context, and those can be used to help inform the analysis. But the court was very clear that you can't just apply the criminal law jurisprudence to the workplace willy-nilly. At paragraphs 98 and 99, the court makes this very clear. Quote, "The court's criminal decisions, such as in Edwards, and particularly in the school context, such as Cole, can assist in determining the existence and scope of a reasonable expectation of privacy in the employment context. However, courts should be cautious in adapting the Section 8 framework from the criminal law context to the employment context. The criminal law context cannot readily be analogized to the context surrounding a principal performing their tasks in accordance with their statutorily mandated role of maintaining order in a school. Criminal law thresholds and considerations related to exigency and law enforcement objectives should not be the starting point of the analysis in the employment context. Rather, in that context, the employer's operational realities, policies, and procedures can be relevant in determining the reasonableness of an employee's expectation of privacy. Criminal jurisprudence should not be indiscriminately imported into non-criminal matters. The analysis under Section 8, being contextual, needs to be adapted to occupational realities. The court then goes on to look at how to determine whether there's a reasonable expectation of privacy, and then whether the search itself is reasonable in the circumstances. To determine whether the individual has a reasonable expectation of privacy, courts and arbitrators have to look at 1, the subject matter of the search, 2, whether the claimant had a direct interest in the subject matter, 3, does the claimant have a subjective expectation of privacy in the matter, and 4, were those subjective expectations objectively reasonable? This analysis is actually very well settled in the case law. Whether the search is reasonable depends upon the circumstances. And the court said the existing jurisprudence for workplace arbitrations, where there is always a balancing of interest between the employer's rights and the employees, are proper considerations for this analysis. The Supreme Court of Canada unfortunately didn't apply this analysis to these particular facts. They didn't expressly say they were adopting the Court of Appeals analysis of this search, but I think that's implicit. At the end of the day, the decision is a bit unsatisfying from a privacy point of view. The court essentially said that for public sector employers, arbitrators have to use the Section 8 Charter analysis, but the analysis that arbitrators already use will get them to the same place. This will mean that a search will be closely scrutinized, and because the Charter specifically engaged, there's likely wider latitude for judicial review. I also find it interesting that none of these decisions, from the Divisional Court to the Supreme Court of Canada, even mention the privacy laws that apply to school boards in Ontario. That would be the Municipal Freedom of Information and Protection of Privacy Act. One would have thought that this law would have had some impact on the expectation of privacy that a school board employee may have vis-a-vis their employer. And always remember, this case is confined to public sector employers. The Charter clearly applies to public school boards in Ontario and likely applies to public school boards in other provinces. I think this extends to government workplaces, but I'd be cautious about thinking it automatically extends to universities, health authorities, and other entities that we generally think of as being public sector. I hope this has been interesting and useful. I try to put out a new video every few weeks or so. So if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian technology and privacy law. Thanks for tuning in.